indulgence in making a mention regarding item number 10 and 11 of the Part 2 hearings. My Lord, as agreed by both the parties, this matter may come up in the next week.
Okay. Who is for the appellant?
Lordship, I am appearing.
Okay. Then both the parties have agreed on the submission made by the learned counsels for both the parties. List in the next week.
Obliged.
Lordship, I am appearing VC from Delhi. Lordship, seeking indulgence in respect of item number 4 of part 2. It may kindly post it next week. I have informed the parties. Actually, I am amicus in this case.
Oh, okay.
Even amicus for the respondent, private respondent has been engaged also. I have
So
informed.
you have informed the other party?
I have informed your Lordship.
Okay. On the heard Mr. J.C. Lalnunsanga, learned counsel for learned amicus curiae for the appellant who has prayed for adjournment of the matter with the consent from the other side. In view of the above, list in the next week. Yes.
For motion, item number 1.
Your Lordship, this is my item. So I'm counsel for the petitioner. Here, my Lord. My main challenge is October 4, 2024, passed by respondent number 5 and 6. In short, they are MFA, Mizoram Football Association. So, my Lord, the punishment is that the petitioners are football players, and one is coach, one is the president of the club. They are barred from the activities, all the activities of football, some of them 5 years, some of them 3 years, some of them 1 year. My Lord, it is not only within the state, throughout the country. That literally it means that they cannot play football at all. And even they cannot accept the offer from outside the state, from another club also. They are professional player. This is their livelihood. So they solely depend on this career. So my chance, allow me to highlight very shortly, Your Lordship. May I please?
See, I have just gone through your petition here. I find that you have addressed a letter to the Mizoram Football Association
Respondent number 5.
To consider your matter. What was
Yes,
their
sir.
reply in this?
My Lord, actually, the moment
A
when
meeting was scheduled to be held on 15 February
Yes,
2025.
of course, my
So
Lord.
what's the outcome of that?
No, actually, they are all over from Sikkim, from Manipur, from villages, and they came on 14 at very last moment. It was scheduled on 15, very last moment on the evening of 14, through telephone, they just simply inform verbally to the respondent number 2 that this consideration of bill has been postponed. And
Let them, you see, you have appealed against some action and there's an appellate authority, I believe, because you have written here to the Mizoram. So let this be disposed of first. We will pass an order.
Definitely, they can dispose, they can consider in the meantime. The thing is that, my Lord, my main point is that MFA has no power even to deal with the
So
appeal
whatever
itself.
it is, you have filed an appeal, isn't it?
Yes,
And
Lordship.
for to consider your matter, and since it was postponed, you have approached this court. So we'll fix a date for them within a
Time
frame we will make, and then we will dispose it of the writ petition. Depending on their reply, only then you can file the writ petition, isn't it?
Much obliged. Your Lordship, one thing is that, my Lord, my
Dispose
point
it
is
of,
that-
we will have a time frame. I'll pass the order later that your letter dated was the date?
14/11?
14/11, where you have
2024.
filed an appeal against the order dated, which is the date? Disciplinary committee. 4/11, yes.
Yes.
Against the petitioner. Okay, I'll pass the order. Heard Mr. J.C. Lalnunsanga, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India, being aggrieved with the order dated 04/11/2024 passed against the petitioners, wherein they were, what is the order?
My lord, order is actually, my lord, if you kindly see page number 6 of my petition, because there are different types of punishment has been given. Some are 3 years, some are 5 years. If you kindly see page number
Okay,
6.
6.
Yes.
Where disciplinary steps were taken against the petitioners, who are what are they, the petitioners?
The petitioners are professional football players.
Who are the professional football players? And the disciplinary committee, AIIF. What is the full form of AIIF?
All India Football Federation. My lord, this thing MFA here in this case, disciplinary committee should be AIFF, All India Football Federation. But in my case,
Okay. Yes.
decision was taken by MFA.
Okay, where disciplinary proceedings was taken against them by the MFA. While it is the,
respondent number 6.
okay, while respondent number 6, while it is the AIFF, AIIF, okay, who is
My lord, I
the
can say respondent number 4.
/ respondent number 4, who has the authority as
Yes.
per the article. What is this code of the code? What code?
AIFF Code 2024.
Okay, as per the AIFF code of 2024. Stop. It was also submitted that the petitioners have filed an appeal against the action of the MFA. White letter dated,
4/10/11.
wait, an appeal, white a letter dated, page what?
Page 62 is my appeal, but I have enclosed only acknowledgement receipt. If you see page 62, there at the bottom you see it was received by MFA.
What
At
is the date of this?
Date is 14/11/2024.
Where is 14/11? There's no.
Relative here, it's at the bottom right side, page number
But
62.
if you look at page 62, Annexure 5,
Yes.
it is only a cost title. Where's the
No, my lord, the
substance
full,
of this
I have
letter?
not enclosed the full copy of petition
You
because
should do that. This title here, but what is the substance? What does it contain? Nothing is here.
I have already submitted to respondent number 5. This is only acknowledgement receipt. If you see that their
No,
seal is on-
but no, please enclose what you have, your appeal, the contents, with the whole thing. It should be enclosed in your writ petition. This is just a cost title, so I'm trying to find what is the substance of and the nature of your
I
appeal,
have
but nothing
written,
is
I
there
have written
here.
in my petition that it is in very same line with this present writ petition. They are all same. I have mentioned in my petition.
No, make it complete, make it complete. You see, it's taken just see, 62 is the appeal petition submitted, so 62, I'm looking at page 62. It is just a cost title, nothing is there. Even it's a bit thick, you do that.
My lord, one thing, may I please, one more submission? In
You
my,
simply saying it's the same, but where is the same? We have to see whether it's the same or not, isn't it? Anyway,
anyway, my
so,
lord,
complete
They
the
received-
documents.
they acknowledge that they receive it because they sent a letter on the next day on 5th December. If you see the next annexure, they receive it.
But what did you send? Just this one paper?
No, I sent the whole copy of
So
agreement.
enclose that. Okay. so that at least it will have some sense. Our order will have some sense when we look at it later, isn't it? Yes. Heard Mr. J.C., learned counsel for the petitioner, who has filed the writ petition under Article 226 of the Constitution for passing the appropriate writ or order against the respondents. Full stop. On perusal of the writ petition filed, it is seen that some documents are not enclosed, and therefore the learned counsel for the petitioner is allowed to enclose the complete documents in the writ petition list in the next week. Enclose that.
Yeah, my lord, that's true.
For omission, item number 2.
My lord,
Yes.
I will be submitting the power in the course of the day, my lord, as well as the objection, my lord.
Okay, so newly impleaded, you're representing the newly impleaded
Yes, my lord.
respondent 5A. Okay, yes. Mr. So-and-so, learned counsel for the appellant is present, along with Mr. So-and-so, learned counsel, who submits that he will be putting the newly impleaded respondent number 5A and will be filing his PAR within the course of the day.
Yes, my lord.
In view of the above list, in the next week.
Yes, my lord.
Okay, wait, we'll list it the next week. Yes, this is an hour.
For order, item 3.
May I please, Your Lordship? My Lord, with your permission, I seek 2 weeks' time, 2 more weeks' time to file my objection, my Lord. In fact, I have received the condemnation petition only earlier this week, my Lord.
Okay, Mr. Samuel L. Sankhe, V. Sankhe, learned counsel. Okay, you're appearing as additional,
It's a state appeal, my lord. Yes,
okay, learned additional AG is present for the applicants, along with Mr. So-and-so.
Lalbiak no namte.
Yes, Lalbiak learned counsel for the opposite party. The learned counsel for the opposite party / private respondents has prayed for time to file their written objection. In view of the above list, 2 weeks, after 2 weeks.
And my Lord, similar prayer with respect to item 4 and 5 also. They're all connected.
Okay, so you are appearing for the private respondents?
Yes, my Lord.
Only private respondents here?
Yes.
yes, my lord.
Same order for item number 4
4 and 5.
and 5.
Deeply obliged, my Lord.
Item 6.
This is an appeal, criminal appeal filed against judgment and order dated 23/11/2023. Passed in criminal trial number 548 of 2020. It relates to matter under the NDNPS Act. And Your Lordship, I have also filed an application for condonation of delay.
More than 1 year to file an appeal, what?
Lordship, actually the appellant is in Lunglei. He was convicted at Lunglei, and it was not conducive for him to contact any lawyer, and his family members are laymen who have no legal knowledge, so it was difficult for him to find a suitable lawyer, and for that reason he was unable to contact any lawyer in Aizawl. So somehow he, at a belated stage, he managed to contact his present counsel, and the appeal was drafted accordingly.
Okay. Heard Mr. Jonathan Weldon Plomer, learned counsel for the applicant, who has filed the instant application under Section 5 of the Limitation Act, Limitation Act is which year?
1908.
Huh?
1908.
1963.
63.
And in this you have written
1908.
1908. 1908 is CPC,
Yes.
isn't it? Those little mistakes, you copy paste and then you leave the, yes. Limitation Act, it is not 1908 but 1963. Limitation Act 1960. Okay, we'll ignore this because I think you must have just copy paste and then forgot to change the date, isn't it? For continuation of delay of 495 days in filing an appeal against the judgment and order dated 23/11/2023 and the sentence order dated 24/11/2023 passed by the learned Judge Special Court, NDNPS Act, Lunglei, Mizoram in criminal trial number 548/20 arising out of Lunglei PS case number 47/2020.
20, Your Lordship.
So many typographical mistakes. Please check, okay? 2020, wherein the appellant was convicted under section 21 within bracket C of the NDNPS Act and sentenced to undergo rigorous imprisonment for 10 years and pay a fine of rupees 1 lakh in default to undergo SI for 10 months. Yes, issue notice to the state respondents. Mrs. Linda L. Pombal, learned PP, accepts notice on behalf of the state respondent. Are you going to file any objection?
Since it's a criminal appeal.
Statutory appeal, no. Full stop. Then, Mr. So-and-so, learned counsel for the applicant, submits that the grounds for the delay of 495 days in filing the appeal has been explained at para 3, 4, and 5, is it?
3,
Yes.
4, 5, 6.
Okay, at para 3 to 6 of the application. Full stop. He submits that the main reasons for the delay is because the applicant on conviction was sent to Lunglei district jail and from wherein he could not contact and counsel to represent him in his appeal, and further his family members being uneducated and financially not well off, were not able to engage a counsel on his behalf immediately. Then Mrs. Linda L. Fombal, learned PP, submits that they will have no objection to the condonation of delay of 400 and something days, 495 days, since this being a statutory appeal. In view of the above submissions made by the learned counsels, this court is satisfied with the explanation given by the applicant for the delay of 495 days in filing the appeal against the judgment and order of the court. Okay, what's the court? Of the Special Court, NDNPS Act, Lunglei Judicial District in criminal trial number 548/2020. Accordingly, IA 20/2025 stands allowed and disposed of. Then in the criminal appeal, on the disposal of IA 20/2025, okay, IA it will be within brackets criminal, okay, 2025, heard Mr. So-and-so, learned counsel for the appellant, who submits that the instant appeal is against the judgment and order, copy paste the whole thing, okay? Full stop. The learned counsel submits that there are sufficient grounds for setting aside this said impugned judgment and order, since the learned trial court what is the main ground? One or two, since
Lordship, one
the
is
learned trial court fails
violations of,
to take note of the fact that the mandatory provisions, is it?
Yes, sir.
Of the NDNPS Act under section 42 and 50
52.
and 52 have not been followed in the instant case. Then new line, appeal is admitted. Issue notice to the respondents. Again, Mrs. Linda L. Humble, learned PP, accepts notice on behalf of the state respondents. Requisite copies of the appeal memo to be duly furnished to the learned PP. LCR, TCR to be called for. List after 2 weeks.
Obliged.
Item 7.
Yes.
Lordship, I am appearing on behalf of the applicant. Lordship, this is an application of continuation of delay for 213 days.
Okay. Heard, Mr.
Larin Sana.
Similar order as the previous one, only it will be condonation of delay is for 213 days. Okay. And the judgment and order is passed by the fast track court, FTC, okay, comma, policy in SC within brackets K number 6/2023 arising out of criminal trial within brackets EX number 4/2023. Wherein the applicant is convicted under section 21 within brackets C/8C of the NDNPS Act. Wait, in your appeal, in your condonation application, where's the judgment? Copy of the judgment should also be enclosed. You are filing a condonation application. Cancel the whole thing. Heard, Mr. So-and-so. Learned counsel for the applicant, who submits that he may be allowed to enclose certain documents which were not enclosed in this instant application. Stop. Praise allowed. List in the next week. Enclose the judgment and order copy. Yes.
Lordship, with regard to that, I'd like to mention that in some cases, they insist on giving the judgment and order, and in some cases they allowed in the registry. And even in these two cases, my lord, the difference is that in one, they have pleaded the complainant, the informant. They insist sometimes, and in some cases they do not insist. So it's quite difficult for us to know which.
No. It's not required in NDNPS cases. It's only when POCSO.
Sometimes they insist, even if we file an appeal. So it's very difficult to know what is important and what is not.
No, there's this thing, Guwahati High Court has passed this, notification in which cases the informant is required to be a party. Please give a copy. Okay, notification is already out based on the judgment. Inquire from the registry. I might be having it with me also in my chamber. Okay, the cases where the informant is required to be a party. It's in the POCSO cases. Then in 376, I think AB, certain list is there only on those cases. Okay, yes. So next week, enclose all the documents. Yes.
Part 2, item number 3.
Lordships, I appeal for the petitioner.
Okay, this is the matter where we had, without extensive hearing, we had admitted the writ petition because you all had submitted that this is a case which could be disposed of at the admission stage, but I think it's better in these matters that they are listed for hearing. Yes.
Not being a regular first appeal, civil appeal, being a writ petition, my lords, the understanding was that in case your lordships felt, that's why we had pushed for an admission hearing. Oh, my lords, the effect is of a full hearing, my lords, is what. So, my lords, in this writ petition, I'll begin, my lords. My lords, the petitioner is a medical officer. She is a Group A gazetted officer. We have annexed the relevant documents of her appointment.
See, in writ petitions, if we find that there is a case which deserves not to be considered for hearing and dismissed straight away, we can dismiss. But you are saying that you seem to have a good case, so we'll have listed it for hearing.
Yes.
Okay, so in admission stage, we just see whether, it's not a matter of two hearings, it's a matter whether you actually have a case or not. If you don't have a case, we dismiss it off straight away. If it deserves to be heard fully, then we list it for hearing. Isn't it?
Yes. So, my lords, I'll get to the matter. My lords, here we are challenging two things. One is the major penalty imposed by the disciplinary authority, which is at, my lords, page 273.
The petitioner was what?
Was a medical officer.
Oh, medical officer. Oh, okay.
Group A gazetted.
Group A.
Yes.
So page?
273. My lords, here, write this order. In 274 is the effective part. It has concurred with the inquiry officer's findings, where the major penalty of reduction to a lower stage in the time scale of pay by 2 stages of a period of 3 years with effect from the date of penalty, with further direction that government servant will earn increments of pay during the period of reduction. On expiry of the period of penalty, reduction will not have the effect of postponing future increments of pay. This is one, my lords. The second order, which we are aggrieved by, my lords, is the order dated 22nd May 24 at 2:75. Next week. Here, my lords, this is the suspension order, the order by which it has regulated my suspension period. It has.
Okay, both of you can leave, we'll call you later. Yes.
My lords, out here, the period of suspension was treated as on duty for all purposes except on pay and loss. So these two, my lords. Now, my lords, your lordships may have the query as to, because, my lords, there are 3 articles of charge which were framed against me, which are at page 39, my lords. This is the memorandum, my lords. At page 41 is the relevant part. Article 1, my lords, if I may read.
Yes.
That the said Dr. Linda so and so, while functioning as medical officer Sialsu PHC, was alleged to have committed grave misconduct in the discharge of her duties against a patient Pulalrenkuya Sialsu, whom she discharged from the PHC without proper discharge certificate in connection with accusing him of stealing her money. So, my lords, I have not discharged him because I did not issue a proper discharge certificate. This is Article 1. Article 2, my lords, this I am not reading. I'll just read, but I have to say that this was not proved. So this is not that relevant, but I'll just read, my lords. That the said Dr. Linda, while functioning as MO, Sialsu PHC, was alleged to have referred patients without proper diagnosis to hospitals and also alleged to have expelled patients from Sialsu PHC. She is also alleged to have shown harsh treatment and discourteous manner to the staff of Sialsu PHC. This is not proved.
Okay.
Article 1 is proved, Article 2 not. Article 3 is also proved. So these 2 articles, Article 3 reads, my lords, that while functioning as medical officer Sialsu PHC, the said Dr. Linda was alleged to sell medicines without drug license from concerned authority, which is in violation of Section 18C of Drugs and Cosmetics Act 1940. Dr. Linda, while functioning as MO Sialsu, failed to comply with the provisions of Indian Medical Council Professional Conduct, Etiquette and Ethics Regulation 2002 and failed to comply with the provision of Para 10.36 of Clinical Establishment Act standard for hospital level 4 and also violated the provisions of Section 18C and thus failed to maintain devotion to duty and committed misconduct, which is unbecoming of a government servant, thereby violating Rules 3, subsection 1, Sub-Rule 1, Clause 1, 2, 3 and 11 of CCS Conduct Rules 1964.
Okay.
The next page is the
1 and 3.
1 and 3. The next page is the imputation. These are more detailed, my lords. Without reading the whole part, my lords, I just want to show your lordships to the relevant part. In Article 1, my lords, the 4th paragraph, right before Article 2, are the violated rules. The substance of the misconduct is the same.
Where we are reading from where?
Article 1, my lords.
Article
Page 42.
1.
Para 4. Therefore, it's
Okay, yes.
Dr. Linda, while functioning as MO, Sialsu PHC, failed to maintain absolute integrity, devotion to duty, and thus committed misconduct, which is unbecoming of a government servant, thereby violating Rule 3, 1, 1, 2, 3, and 11. Now, my lords, these are the charges against me. Now, my lords, I will come to the part of the, my lords, whether a report can evaluate facts or not. I have seen your lordship's judgment, my lords, in a case, but our case is different. Our case is that there is no evidence and the findings of the IO are perverse, my lords. I will come to that later. My lords, the genesis of the whole departmental proceedings is due to the WhatsApp message which was circulated and which is at page 46.
Okay.
My lords, this is the vernacular. In the next page is the translated version. I'll just read this, my lords. Shri Lal Renkvi of Sialsu had been admitted in Sialsu PHC for various health issues. His oxygen, I'll just say, oxygen couldn't reach even 70, and his conditions is not good. His doctor did not have drug license and still selling drugs in the hospital canteen. She herself stated that her higher-ups gave her the permission to do so. It is heard that she used to prescribe lots of medicines related to COVID cases. Then rupees 1,000 was lost from the pharmacy and Pulal Renkuya was blamed for theft. At night time, she removed all oxygen and expelled him out of the hospital and told him not to come to the hospital anymore. Without any proper discharge, when Lal Rengpuya was very tired, other patients' relatives who felt very sorry for him dropped him home at his house. Should have been. From the next day, he could not be properly and couldn't even wear underpants as his private parts were paining. That night, that is, my lords, the next night, he passed away. Sri Renga has left his 3 children, age 3, age 1 month, and 1 year and 4 months it should have been, and a little baby 2 months old. Sri Renga was only a day laborer and lived in poverty. Sri Renga used to drink alcohol and did not live the life in all godly ways, but anyone that does badly things also get the treatment they want in the hospital. The way they did things to us is very cruel. Some of Renga's siblings and family were heartbroken. They submitted FIR after 1 week. When the doctor heard about this, she took her staff to ask for their forgiveness. Renga's wife, absent-mindedness about her husband's death, and with all her children, she just said yes to whatever they're saying. Her house is very small and bad, and feeling ashamed of her home, she couldn't think straight and said yes. We all went to the funeral as it is my husband's first cousin, and we cannot stop thinking about how they treat him and furious about how they said if they ever go to the hospital, they will not treat him. My lords, just mark that part where we also went to the funeral as it is my husband's first cousin. Because, my lords, the person who had circulated this WhatsApp message in Sialsuk village never came forward. But your lordships will see that we feel that though it is not specifically in the record, it is one of the state witnesses. It will come from, when we reach them, I know it will become clear. The disappearance of rupees 1,000 is not caught red-handed. Our brother also said, I did not take it with a feeble voice. Even if he took it, it was not worth his life. His elder sibling is also very poor, and along with the church elder, both of them received the doctor and the staff and forgave them. We are not content with all these things happening, and the families are also divided. All these things we said are facts, and we did not add anything. If the hospital did not kick him out and treat him properly, the question we have is, will he still be alive? That only God knows. A good doctor who loves their patients. We all know that some people who are good and giving all their time and money are out there, but when we are bedridden or in serious health condition, we trust the doctors more than we have trust in God, and that shows how much we value the doctors. So, my lords, this was circulated. Because of this circulation, my lords, the proceedings were initiated, my lords. I've taken your lordships through the memorandum of charge. Next is your lordships. I'll take your lordships directly to the statement of defense as to show what was the stand of the charged officer. This is that page, my lords. If I take your lordships to page 51, this is the statement of the charged officer, Dr. Linda. And the translated version is in 54. I'll just read, my lords.
Yes.
My name is Dr. Linda, so-and-so. My husband's name is so-and-so. Presently residing at house number so-and-so with my family. The followings are the things I would like to state about where the medicines were seized by the police at the Sialsuk PHC labor room on 3rd June 2022. On 15 September 21, I was appointed as medical officer at Sialsuk PHC. Before joining this work, I took charge from Dr. H.J. Nunpuya at CMO office, Azol West office. On that day, owners of MS Pharmacy Chanmari West and Dr. H.J. Nunpuya were also present at the time. They told me that Sialsuk PHC is far from the town center and it is difficult to find medicines for patients in emergency. Your lordships would recall it was the COVID period. They also told me that labor waiting shed is no longer used and would be convenient to sell the medicines. They further told me that they also used to stock some medicines as sometimes the medicines were not available at Sialsuk village. I know nothing about selling and management of the medicines, that I did not know what is right and wrong regarding the law. I think the way they did will be very convenient for the public. When I arrived at Sialsuk PHC, so my lords, just to briefly put, as per her statement, it was MS Pharmacy who was selling it, along with one local license holder, my lords, will come. When I arrived at Sialsuk PHC, I saw the problems of medicines with my own eyes. After that, MS Pharmacy called me through phone that they were going to visit us, and I accepted. On that day, they brought their medicines and kept the same in PHC labor waiting shed. After that, MS Pharmacy had agreed to pay Mal Somdong Liani rupees 5,000 per month as storekeeper. MS Pharmacy also searched for a drug license to borrow.
Who is this MS Nongliani?
My lords, this is the one girl who was, my lords, stationed there in the waiting shed as
Okay.
storekeeper. Different person altogether.
Okay, as storekeeper.
Yes. I am not the one selling, my lords.
Okay.
MS Pharmacy also searched for a drug license to borrow. The holder of the drug license, Sri Thanswala, is an old age person. So MS Pharmacy had given his daughter, staff nurse Lal Choi Moi, per month for the fees of borrowing the drug license. Who gave, my lords? The MS Pharmacy. Then the remaining sales of medicines are usually sent to MS Pharmacy. My only involvement was to tell the patients that medicine will be sent according to their needs. I had no benefit from this shop, but I consider it to be easier and more convenient for patients and the public. Those medicines which were seized by FDA on 3rd June 22 are the remaining stock which were yet to be sold by MS Pharmacy. I have no reason to say that the medicines are owned by me. I saw the seizure of the remaining stock of medicines, and thus I am aware of the said seizure. Because of the above, I cannot at all claim ownership of the said medicines. The aforesaid said statement given by me is true and correct. If I have violated any law, so and so much. Now, your lordships, the next page is the statement of defense, wherein I had stated what was the true nature insofar as the Article 1 and 2. I'll take your lordships, and your lordships would find, my lords, today our case is not that, your lord, we are seeking for this honorable court to replace the findings of the inquiry officer. That your lordships had said in 2 judgments I've seen, my lords. That judgment we agree with. But where the findings are so perverse, and it is not, and the charges are not within the, and the charges are not which were in the imputation of misconduct, those, my lords, the charged officer cannot be found guilty. And there, my lords, Supreme Court has also said, my lords, interference is warranted. So, I'll take your lordships through this, my lords. I'll come to the judgments later. I'll just take your lordships through this.
Page?
Page 58.
Oh.
I'll read my lords. The articles of charge against my client, Dr. Linda, under suspension has arisen due to Sri Lal Rengpuya, patient who voluntarily left the PHC without the knowledge of an informing nurse on duty on 12th May 2022 at 6:30 p.m. So, my lords, this Lal Rengpuya had actually left the PHC on his own. That was our case. And we had also prepared a discharge, but he wasn't there when we tried to give it to him. And who died on 13th May 22, that is the next day around 9:30 p.m., that is in the night. The death of Sri Lal Rengpuya was exposed by YouTubers and WhatsApp messages by general public and his close relatives. According to the WhatsApp messages and YouTube, the death of the patient was attributed due to his driven out from the PHC by Dr. Linda Lalbiaknungi. And that Dr. Linda is also charged to have sell medicines without obtaining drug license, but by lending the drug license of others. The sale proceeds of the medicines amounting to rupees 1,000 was stolen by some miscreant, and that Sri Lal Rengpuya, who was the only person who entered into the said hospital canteen, was expelled from the hospital due to suspicion. The sales girl, the waitress of the canteen, highly suspected Sri Lal Rengpuya to be the person who had stolen the sale proceeds of rupees 1,000 and questioned him if he had stolen the same, but he refused to confess. Thereafter, Dr. Linda Lalbiaknungi was informed about the stolen money, stating that she had locked the door of the house with socket bolt only and went outside for a while. My lords, this is the storekeeper saying this. When she opened and checked the sale proceeds, she found that a sum of rupees 1,000 was stolen by someone, and that Sri Lalrengpuya patient was the only person who entered the building, as was witnessed by other patients and their attendants. Sri Lalrengpuya late himself admitted that he opened the door and entered into the building due to the reason that a rat had entered into the canteen, and he followed the rat with intention to kill. But there were no hole for entering the rats at the skirting of the building or from the door, as it was closed and locked. Thereafter, around 6 p.m., my client also asked Sri Lalrengpuya to confess if he had stolen the money, but the said patient failed to confess. As a result, my client said to him, "You are the only person who entered into the building, and if you do not like to confess, do you want to discharge from this hospital? Otherwise, your behavior and integrity is doubtful for security of the hospital and other patients." My lords, the next speech. Sri Lalrengpuya answered her yes. Then my client left the patient from the ward, and at first she was willing to release him on the morrow. But immediately after the doctor left him, Sri Lalrengpuya had voluntarily pulled out his oxygen pipe by himself and switched off the plug and went home without informing nurse on duty and doctor who was in nurse duty room. Sri Lalrengpuya did not demand and did not wait for discharge certificate from hospital authority and left the hospital. However, other patients' attendant dropped him by their vehicle up to his residence. The matter was informed to the said doctor that Sri Lalrengpuya patient had left the hospital around 6:30 p.m. Accordingly, my client prepared discharge certificate in favor of the patient, and that Sri Lalrengpuya was a drug addict. He was earlier admitted twice to the PHC by my client on 13 November 2021 and discharged on 15/11/2021, again on 13 April 22 and discharged on 19 April 22. On 1st May 22, around 7:30 p.m., Sri Lalrengpuya was brought to the PHC as he was unconscious due to drug overdose, since the medication needed for drug overdose was not available at Sialsu PHC. She referred him to Thenzol CHC for treatment after confirmation of availability of medicine for his treatment from the doctor in charge of the CHC over mobile phone. With regards to his personal life, Sri Lalrengpuya was always arrested by Sialsu police due to robbery case, but in most cases, he failed to confess himself and were released without registering criminal case against him. However, 3 times criminal cases were registered against him by Sialsu police station due to theft cases. Wide PS case number, my lords, they had provided these letters from the OC. Para 2 of the next page at page 60, that my client joined duty at Sialsu PHC on 15 September 2021, took over charge from Dr. H.J. Lalnunpuya. That under Annexure 1 of Article 3, Para 1, she is alleged to have sold medicines without drug license in violation of Section 18 of the Drugs and Cosmetics Act 1940, and in Para 2, she failed to comply with the provisions of the Indian Medical Council regulations as well as Para 1036 of Clinical Establishment Act standard for hospital level 4 and Section 18C Drugs and Cosmetics Act. That under Annexure 2 under Annexure 2 of Article 1, 2 and 3, she is charged to have failed and not complied with the requirement of Para 1036 of Clinical Establishment Act standard for hospital level 004. That the Drugs and Cosmetics Act 1940 are not adapted in the state of Mizoram other than the following acts, which are, my lords, the following. The next speech is, my lords, the continuance, my lords. But, my lords, out here, I will just sum up. Here, my lords, the defense assistant of the petitioner had basically stated that to find the CO guilty of Article 3, which was selling medicines, the 18C of Drugs and Cosmetics Act was not properly notified by the proper department. And my lords, for now, my lords, that I'm not pushing right now. I'll take your lordship straight to the inquiry report. My lords, the inquiry report, it starts from page 171. And I'll just jump through certain pages because, my lords, our main submission is that it is a case of perverse findings. The evidence was not properly considered, and in fact, it is a case of no evidence. My lords, the page 174 states again what is the articles of charge which were framed against him.
So where's the finding?
Yes, my lords, the findings I will come straight. So far as Article 1, my lords, it is in page 232. It starts from 232. Yes, my lords. It may be mentioned here. My lords, before I take your lordships through these findings, can I take your lordships through the statements of witnesses?
Okay.
It will be very material.
Yes, okay.
My lords, the statements starting with the,
How many witnesses?
my lords, there were together 10 state witnesses. 10 state witnesses.
Page?
My lords,
Some of them will be more or less the same.
More or
So
less
I
the
don't
same.
think you have to read
My
everything
lords,
out.
4 of them who I say are interested witnesses and who have been the only statements on which the IO had relied, they are ditto same, my lords, ad verbatim same.
Okay, page?
My lords, the pages are at page 178 onwards.
Yes.
My lords, the middle says, examination of state witnesses, defense witnesses. It may be mentioned that when the regular hearing on the case was held on 19th August 22, the PO produced 10 witnesses, numbers of state witnesses on behalf of the disciplinary authority. And an examination in chief was done by her and the CO along with the defense assistant who were given chance. I'll start, my lords, statement of Thantroami. And my lords, I'm sorry, this is all vernacular.
Yes.
The translated is in page 188 onwards.
188.
88. Yes.
Okay.
Your lordship says.
Yes, who is this?
My lords, this is Thantroami. He is, my lords.
Wife of the deceased.
Yes.
Oh, okay.
My husband, Lal Rengpuya, has fatty liver, asthma, and gastritis. So we went to Sialsu PHC on 9th May 2022, Monday, for OPD. After the doctor asked him about his illness, and we told her about his illness, she asked us if we wanted to be admitted. It's up to you, we said. And we were admitted. The day we entered the hospital, my husband BP was checked and it was 110 by 150. He was dizzy and his oxygen level was 60. After this, I left because I had to tend to a hungry baby. After I returned home at 2 p.m., he called me through phone that he was hungry and I gave him food. After this, I went back to our house. 9th May, my lord, he was admitted. On 12th May 22 at 5:30 p.m., Roatsanga PHC grade 4, wife Byak Sungnungi, called me through phone and told me that the canteen money was missing and he was suspected. After this, she again called me through phone around 6 p.m. She told me that the doctor called me and told me that Renga stole the money and that he refused to confess and told me to take him as his family doesn't have a car to take him home. Then we waited for my husband to come home at around 7 to 7:30 p.m. Some Lukhai villagers who were in the hospital got my husband home. He was tired and breathless when he came home. He used VLTF oxygen. I asked him if he stole the money. He replied, I didn't steal at all. This night, he woke up twice to urinate. 13th May. In the morning, our 6-year-old daughter and my husband went out to manage rice. He was tired on the way. He asked for rupees 110 from me for the debt we had to pay while taking the rice. He also told me that he paid the debt after he returned. He was tired and oxygen was not available due to lack of current. He loitered in the house and then we prepared the meal. He also ate a little. He has urinary incontinence during the day and tried to urinate. He also used to pull his underpant on and off. He asked our children to tie his toes with thread. Sometimes he would sleep and then get up. He did not eat that evening. He was too tired, so he couldn't eat. We waited for him to eat, but he didn't want to eat. At night, he used to walk round and round the house. Oxygen is not available because the current is not good. I asked him to go back to the hospital, but he refused, saying that because the doctor told him, if you come back, I won't take care of you anymore. He said that my genital is hurt and he could not control himself from walking naked in front of his wife and children. We then were sleeping in bed while my husband slept on the chair and he couldn't sleep. Outside and inside, he walked around. When he was tired, he used to sleep on the chair. Between 8:30 to 9, we heard him falling from his chair. We tried our best with oxygen as much as possible, but to no avail. So, my lords, this is the statement of the wife of the deceased. In examination in chief, he says, cross-examination, my lord, examination in chief by the presenting officer, he says, my husband Renkuya was also previously admitted to Sialsuk PHC. Previously, Sialsuk PHC issued discharge certificate regularly. On 12 May 2022, he did not discharge his discharge certificate. He did not say anything about the doctor's treatment on the night of his release, May 12, 2022. On the night of 13th May 22, I saw him suffering from pain, but he did not want to go to the hospital, saying they will not take care of me anymore, even on my insistence to go. On cross, she said, my lords, they will not take care of me anymore are my husband Renkuya's words. On 13 May 22, Sialsuk PHC MO, a medical officer, did not call me or tell me to get the discharge certificate. My husband Renkuya was a self-employed man. My husband Renkuya used to drink alcohol and also took drugs in the past. We got married at the end of 2015. I don't know anything about my husband's character before we got married. Once I'll take your lordships next to the statement of Darzami, who is an employee in the PHC, grade 4. I work in this hospital like cleaning the ward, helping the nurses when there are patients and doing whatever the doctor tells me to do. I was there as grade 4 duty on the night Sri Renkuya was discharged. On the night of 12th May 22, Dr. Linda Lalbiaknungi visited Renkuya's ward and asked him about the lost money, rupees 1,000. She asked Sri Renkuya, have you stole it? I haven't, he replied. After asking the questions, she said, I am going to discharge you. This happened when I was in the ward. After this, I left the ward and went to duty room. When I went back to the ward from the duty room, he was already discharged. There was no current, but the inverter was on. I didn't see him. That night, the doctor came to the hospital because of the loss of canteen money. After Sri Renkuya's exit, the doctor returned home. After this, I don't know anything about Sri Renkuya. In her examination in chief by presenting officer, she says, on the night of 12 May 22, I saw Dr. Linda Lalbiaknungi in the ward of Sri Renkuya. I think she shouted on him. I never saw Dr. Lalbiaknungi shouted on her patients. There were times when me and other staffs were shouted by her. In her cross, she says, before and after the arrival of Dr. Linda, we used to clean the PHC and its surroundings. Dr. Linda morning routine for cleaning of the PHC and its surrounding area was very good for me personally. Dr. Linda is the one who bought us chemicals for spraying on the weeds. In the past, we used to collect the money and bought the chemicals, and sometimes the PHC bought them for us. Next is, my lords, statement of another employee of the PHC. My lords, all these statements I'm reading out, my lords, because the perspective will become clear, my lords, how the findings have been reached. Statement number 6. Cooking is my job in the hospital. Our boss doctor called me when Renkuya was about to release and said, Money is missing. I'm going to release him, take him out. While I thought he would come home to my house, but the patient's attendees from Samlukhai village brought him home. I was not there when the incident occurred. I don't know anything about him till they called me when he was about to die. Rengpuya is my wife's sister's husband. So my lord's related to the deceased. Dr. Linda never shouted or hated me. I am a cook. I don't see her at all. I have never heard of her being rude to other staffs. I have heard a couple of people praising her. I have never known her as a person hard to deal with. In the cross, she says, Sri Rengpuya is my wife's sister's husband. I wasn't there when he was left the hospital. I don't know anything about him when he left the hospital. The next is, my lords, this person was referring to one, she is my wife's sister's husband. Next is the wife, Pitsoy Mohi. When the incident occurred, it was during COVID quarantine and I could not go during the time. We have a medical license. Some patients' needs were so high that my boss, doctor, used my license to take medicine. But I believe she does not take medicines using my license because of complaints from other pharmacists in the town. Since March this year, she has stopped using our license due to complaints. My father's drug license was used by Dr. Linda Lalbiaknui, which is RT drugstore. After this, Dr. Linda Lalbiaknui sells the drugs in the name of Gilead drugstore, that is 18th April 2022. Dr. Linda Biaknui is not a bad colleague to work with, and I don't think she was ever rude to other staffs. Dr. Linda has never discharged any other patient without issuing a discharge certificate. I didn't know anything about Dr. Linda discharging Sri Rengpuya without issuing a discharge certificate. In cross, she says, my husband's name is Lalrem Tluanga. Sri Lalrengpuya's late mother, and my husband, mother are sisters. WhatsApp messages are not spread by me.
So this person who spread the WhatsApp messages.
Yes, we
who's that
suspect it is
person?
this person.
Okay. Name of that person is not known. Is
Yes, ma'am. It's not.
it? Okay, let's read.
Yes, ma'am. I'll go on. Statements of Michael Relrinmoyo, ophthalmic assistant. I don't know anything about the discharge of Rengpuya from the hospital. I wasn't there and it was outside my duty hour. Since on 23rd May 22, Rengpuya's family filed an FIR. The OC came to the PHC to take an inquiry. The doctor said to us she would apologize to them for the incident and we all agreed. On 25th May 22, VC called YMA for meeting. I did not attend the meeting as I am a member of the department and the other OB attend the meeting. Regarding Dr. Sri Lalrengpuya's discharge on 17th May 22, I talked to the doctor and told her that I feel sorry about the incident. It should have been 12th May, but my notes, this is 7th. And told her that it would have been good if she first informed us or police. We then had welfare meeting. Secretary and assistant secretary and I discussed the matter. So we went to Sri Rengpuya's house. On the way, we asked Sri Rengpuya's family that if it is available for Dr. Linda to come to apologize. At 1 o'clock, we left them for family meeting. We went with our health supervisor. After Dr. Linda Lalbiaknui had apologized to Sri Lalrengpuya's family, Pusoma, Pudar Rimoi and his family members said, apology is our only demand. You didn't come early, so we filed the FIR, they said. They expressed their forgiveness in the name of God. They welcomed us warmly and we were able to get along. They also said that they forgave us kindly and they will also withdraw the FIR. I worked with the charged officer for 8 months. I am not aware of any other patient being discharged from the PHC without a discharge certificate during our work together. I have never heard of any incident when she used any bad words or behavior towards the staff. In cross, he says, we have no relationship with the patients. I know that Sri Rengpuya was in the PHC before this incident. I don't know how many times he was there. Sri Rengpuya was not free from drugs, I have heard. Next is, my lords, one of the storekeeper, one of the nurses known to use bad words and bad behavior towards the staff. We at Sialsu community are very dissatisfied with Dr. Linda and pray for severe punishment. My lords, I won't take your lordships through the cross.
But this is what has been reproduced in the next. This is YMA secretary. Same, my lords, ad verbatim. Same for the next 2-3 witnesses. Now, my lords, I'll just take your lordships to the defense witness, what they have stated at page 196. Only 2 defense witnesses. The first is, my lords, one person whose child had been admitted, my lords. From 15th January to 27 July 22, I was admitted to Sialsuk PHC. We are admitted to the PHC because of our child's heart disease, because of the need for constant oxygenation. During our stay, I didn't even hear Dr. Linda shouting at her patients. I think she keeps her time and schedule right. We know each other when Sri Rengpuya stay at Sialsuk PHC. I did not see him going into the canteen. I didn't even know he went into the canteen. I never saw Sri Rengpuya using oxygen. I only saw him twice. Our rooms are connected. In her cross, she says, I only heard from someone else that Dr. Linda shouted at Sri Rengpuya. We've never heard of Dr. Linda Lal Biaknungi shouting at her patients or staffs. We usually went to the hospital because of our child's illness, and they gave us a discharge certificate. When they referred us to go outside, I cannot recall if discharge certificate was issued to us. While we were leaving, Dr. Linda was no longer there. Dr. Manuna was there. In the next, my lords, is another defense witness who used to work in the PHC. When I worked at Sialsuk PHC, I've never known Dr. Linda to shout at the patients and staff. Sialsuk VCP statement that Dr. Lalde Aknuni used to parade her staff is not correct. We never paraded. I have no idea about Dr. Linda selling any drugs. The distance between the canteen and the PHC, my lords, is very important. The distance between the canteen and the PHC is about 9 to 10 feet. I was in Aizol when Sri Rengpuya was discharged from PHC. I don't know anything, no prospects. Now, my lords, I'll take your lordships straight to the findings of the inquiry officer. Page 232, so far as Article 1 is concerned. May I, my lords?
Okay, you can read, but the interference of the court in disciplinary proceedings is very limited.
Your
Anyway,
lordships
so we'll see.
Your lordships is right, but I
So
will
we'll see.
take your lordships. Yes, my lords.
Anyway, go ahead.
My lords, from the third paragraph, it may be mentioned here that this unfortunate incident come into picture following the missing of money amounting to rupees 1,000 from the canteen, which is stated as the sale proceeds of medicines. There, the said Purempuya was the main accused of stealing the said money, and hence the confrontation arose between himself and the CEO, as the CEO greatly suspected him, knowing well the past history of the former. The statement, the state witness 6 stated that as per telephonic conversation with the CEO was intending to discharge the said Pulal Rengpuya. This is the cook, my lords. On the night itself, on account of the said missing of money, and the said Pulal Rengpuya failed to confess his responsibility on that for which he was informed to bring the said Pulal Rengpuya home. Further, the state witness 2 also stated that the CEO has confrontation with the said Pulal Rengpuya in connection with the missing of the said money, thereby charging the latter as responsible person for that missing money. The SW2, state witness 2, further stated that the CEO told Pulal Rengpuya that she was going to discharge him for that reason, and when she returned to duty, she found that Purengpuya had already left the PHC, and the CEO also went to her quarters later. Further, the deposition of 5 state witnesses, the state witness 9, 11, 13, 14, 15, these are the community leaders, testified the oral statement made by the CEO in her quarters that she did not discharge the said Pulal Rengpuya properly, for which she apologized. These specific statements of the statements are not crossed by the charge officer or her defense while regular hearing was held. Further, the state witness 1 also mentioned that her husband Purengpuya did not bring home the discharge card on that occasion. She further stated, as the illness of the said Pulal Rengpuya escalated, she proposed to go to the PHC again, he refused it, stating that the PHC may not like to entertain him anymore. On analysis of the facts and circumstances mentioned above, it may be mentioned here that it is very unfortunate for both on the part of the CO and the said Purengpuya that the former did not issue formal discharge certificate in favor of the latter. At the same time, the illness of the latter escalated and died later, which caused great annoyance and gossip in the public, thereby suspecting the CO that she's expelled the latter from the PHC, thereby causing that consequently. My lords, that suspicion is very important. Because, my lords, the law, as per my understanding, is that suspicion cannot take place of proof, even in preponderance of probabilities, my lords. Has such missing of money not happened, things may become different, and it may be assumed, he says, my lords, that the said Purengpuya might have been discharged from the PHC properly by the CO as were done earlier. Therefore, it could be seen that everything could not be dealt with smoothly by both the CO.
Function medical officer and to maintain.
Violating Rule 3.1, 1, 2, 3 and 11, not 9. He's found me guilty for something else.
Okay, so you're saying that 9 was not mentioned in the
9 was not
article of
mentioned.
charge. Okay.
And, my lords,
Oh,
the substance of Article 1 is that I did not discharge him properly because I did not issue the discharge certificate. But what is the finding? The finding is that I did not act smooth enough because the inquiry officer at page 233 says that actually the discharge certificate was prepared. Now, if a patient, my lords, willfully exits the hospital, how can I run after him and give him, even though I've prepared? And, my lords, the finding is what? The finding is that I did not act smooth enough. Though he's found, the IO has found me to prepare the discharge certificate.
so what's Rule 3.1?
Yes, ma'am.
3. He's found guilty of that. What is that?
Every government servant shall at all times maintain absolute integrity, maintain devotion to duty. 3 is do nothing which is unbecoming of a government servant.
So unbecoming of a government servant.
Yes.
Was it heard? Of course, we shouldn't look into the facts so much, but is it unbecoming
Yes.
of a government servant when the doctor acts as a police officer and questions, did you steal?
My lords, but that is not the charge against me.
Anyways, isn't it so when this unbecoming of a
Yes.
government servant is very wide?
No, correct, my lords. But I'm not on that. I am on basically that if a misconduct has been alleged against me, that you have done this wrong.
So,
That has to be
without proper discharge certificate in connection with accusing him of stealing money.
in connection. But the actual charge is, my lords, that you have not discharged him properly because of non-issuance of a discharge certificate.
Anyways, accusing him of stealing money, is that becoming or not? That also could be a question. Anyways, go ahead. Next point.
Your lordships,
Okay, 9 was never mentioned. What is 9?
9 is, my lords, maintain accountability and transparency.
Okay. That's one. Next.
That's it. My lords, may I put some judgments on record? Because I'm seeing what is falling from my lords.
Then another
must-
ground if the punishment
Yes.
is so severe that it is not
Yes.
commensurate the action done. That's another ground in which an appeal can be
Yes.
made.
Article 4, my lords. Rule
So
4.
that will look also. But
Yeah, later.
anyways, your judgment.
Here, my lords, I would like to take your lordships to sub serial number 5. Actually, my lords, if we go from judgment by judgment, I've extracted the relevant judgments. My lords, in R.R. Parekh versus High Court of Gujarat, relevant para I've quoted, para 19. The High Court, while exercising its power of judicial review under Article 226, has to determine as to whether the charge of misconduct stands established with reference to some legally acceptable evidence. Second, my lords, this is 2016 judgment by the Supreme Court, my lords. Narinder Mohan Arya versus United Insurance Co. My lords. I'll read, my lords, para 24. In its judgment after remand, the learned single judge quoted almost the entire of the order of the inquiry officer and without discussing the issues raised therein held. Sub para 1 I have not quoted, sub para 2, my lords. It is settled principle of law that High Court cannot sit as a court of appeal over the findings of the appellate authority. And that is the reason the Honorable Supreme Court in various judgments said that while dealing with such like cases, we have to make a distinction whether it is a case of some evidence or of no evidence. In para 26, the Supreme Court says, in our opinion, the learned single judge and consequently the division bench of the High Court did not pose unto themselves the correct question. The matter can be viewed from two angles. Despite limited jurisdiction of a civil court, it was entitled to interfere in a case where the report of inquiry officer is based on no evidence. In a suit filed by a delinquent employee, a civil court also a writ court, in the event the findings arrived at in the departmental proceedings are questioned before it, it should keep in mind the following. The inquiry officer is not permitted to collect any material from outside sources during the conduct of the inquiry. 2. In a domestic inquiry, fairness in the procedure is a part of principles of natural justice. 3. Exercise of discretionary power involves two elements, objective and subjective, and existence of exercise of an objective element is a condition precedent for exercise of the subjective element. 4. It is not possible to lay down any rigid rules of principles of natural justice, which depends on facts and circumstances of each case. But the concept of fair play in action is the basis. 5. Inquiry officer is not permitted to travel beyond the charges, and any punishment imposed on the basis of finding which was not the subject matter of charge is wholly illegal, my lords. 6. My lords, suspicion or presumption cannot take the place of proof, even in a domestic inquiry. The writ court is entitled to interfere with the finding of the fact of any tribunal or authority in certain circumstances. Now, my lords, Roop Singh in this Supreme Court judgment, this is very, my lords, pertinent. Para 4, the judgment says the purported confession, because the statements was that of those community leaders, your lordships would recall, was that the CO had admitted before them. That was the only one. The purported confession by the appellant was also not proved, only because the said confession was made before the police authorities. The inquiry officer inferred on the basis thereof that
Yes, please go ahead.
that the appellant had connection with those persons who had used those bank drafts. 10. We have noticed herein above that only basic evidence whereupon reliance has been placed by the inquiry officer was the purported confession made by the appellant before the police. According to the appellant, he was forced to sign on the said confession as he was tortured in the police station. Appellant, being an employee of the bank, the said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft book. Admittedly, there was no direct evidence. There was no indirect evidence. The tenor of the report demonstrates that the inquiry officer had made up his mind to find him guilty, as otherwise he would not have proceeded on that basis, that the offense was committed in such manner that no evidence was left. My lords, out here, I just want to take your lordships just to two further paragraphs which I have not quoted here. If your lordships goes to the tagged, my lords, the stick-ons that I've put at 3, my lords, judgment number 3. And if your lordships goes there to para 14 of the same. This is in Group Singh, my lords. Para 14.
Yes.
I'm sorry, my lords. Para 15, we can go straight to para 15. And your lordships, in another judgment I've seen, your lordships have quoted this judgment, MV Vigilani, para 15. I'll read. Although the charges in the departmental proceedings are not required to be proved like a criminal trial beyond all reasonable doubts, we cannot lose sight of the fact that the inquiry officer performs a quasi-judicial function who, upon analyzing the documents, must arrive at a conclusion that there had been a preponderance of probability to prove the charge on the basis of the materials on record. That means, my lords, what the charged officer has put on record and the defense. While doing so, he cannot take into consideration any irrelevant fact. He cannot refuse to consider the relevant facts. He cannot shift the burden of proof. He cannot reject the relevant testimony of the witnesses only on the basis of surmises and conjectures. He cannot inquire into allegations with which the delinquent officer had not been charged with. My lords, the purpose of these judgments is that, my lords, the charge is very specific, my lords. That I did not issue a discharge certificate in connection with something is something else, my lords. Because your lordships had said that the FIR and the reporting, the questioning. After all, my lords, I am looking after the hospital canteen under my management. I might inquire, my lords, but that is not any misconduct. The misconduct is whether
But
or
the
not.
charge is, anyways, go ahead.
Yes.
It's very wide, Rule 3.
No, my lords, the rules there, your lordships is absolutely right when your lordship says it is wide. These are the conduct rules, my lords, that is there. But the substance of the allegation, the misconduct has to be proved. And so at page 233, my lords, what has been found against me, my submission is that I have not acted smooth enough because the discharge certificate was placed on record. It was just that the patient had left on his own volition. And my lords, that is the thing, that he has gone beyond the allegations of misconduct to find me guilty under these relevant provisions. That is on Article 1.
Okay, yes. Then the next charge?
Article 2, my lords, is not proved, which is at page 236.
So the second article, the third article of charge, the third one.
Third one, my lords. Third one is that I have sold medicines.
Okay.
Therefore, my lords, again, conduct rules, that is violated. But the charge is that I've sold medicines. Page 240 is the findings.
Yes.
My lords, page 240, I'll read. On the assessment of the evidences thereof, it could be seen that there prevailed violation of Section 18C of the Drugs and Cosmetics Act 1940 in the Sialsuk PHC during the relevant periods. And at that time, the medical officer was the CEO there. There was lending or borrowing of the drugs license of Puthanzwala Sialsuk by the CEO as stated by SW8. The CEO also admitted in her written statement of defense she acted as a mediator delegate between the owners of drug license, namely Puthanzwala, Sialsuk and Messrs Pharmacy for supply of medicines to Sialsuk PHC canteen for sale. And when Puthanzwala withdrew his drug license from the CEO, it was continued in the name of Gilead Drugstore. This is testified by confiscation of drugs, medicines by the FDA on 3rd June 22. The CEO was the medical officer in charge of Sialsuk PHC at that time. However, the CEO denied that she has no benefits from such selling of the said medicines in any way. This denial of the CEO could not be testified even though there may be an existence of preponderance of probability, but it could be clearly testified that she played an important role in the lending, borrowing of the said drug license and selling medicines in the premises of Sialsuk PHC in violation of Section 18C of the Drugs and Cosmetics Act, and also the said circular issued by the JD Food F&D, Controlling and Licensing Authority, Directorate of Health Services. The CEO, being the administrative head of that Sialsuk PHC, is supposed and expected to know all the relevant rules and order of circular which may be issued from time to time by the government, and the same may have relevance with her professional as a government medical doctor, but the CEO did not enforce it. Further, she is also expected to maintain the smooth functioning of the said PHC without any blame, whether from the individual or community. Instead, it is testified as admitted by her in her written statement of defense that she acted as mediator delegate in instant case. Further, members of the NGOs by their statements testified that CEO did not deny that she was selling. This is the main crux, my notes. Further, members of NGOs by their statement testified that CEO did not deny that she was selling medicines in the said premises of Sialsuk PHC during the relevant periods, which is not crossed by CEO during course of inquiry. Further, it appeared that this practice of the CEO made annoyance and complaint amongst the interested drug sellers in the locality, which is undesirable in the daily smooth administration of the government. If running of the drugstore in the premises of PHC is felt necessary, the CEO has to act accordingly. The provisions of the existing rules of standing order governing such action, but it failed to do so. Further, the contention of defense assistant that Drug and Cosmetic Act has no legal validity in the state of Mizoram, as the same are not adapted by notification and publication in Mizoram Gazette. And similarly, the circular issued by the JDF&D Controlling Directorate of Health Services based on Section 18C of the Drugs and Cosmetic Act has no relevance in absence of such adaptation order, may not be tenable at this juncture, and may be placed at the discretion of the administrative authority accordingly. Taking into account all the facts and circumstances mentioned above, the allegation of the CEO of the article of charge 3 that she violated provisions of Rule 313 and 8. 8 was not there in my lord's statement of imputation, is proved. So mainly, my lords, it is on the reliance of the witnesses.
Yes. Okay.
Now, my lords, I just want to take your lordships to what evidence did I put on record, the documentary evidence. Your lordships may first see, my lords, the discharge certificate. I am coming back to Article 1. The discharge certificate.
Yes, where is it?
Page 114. My lords, I had
Issued on
that date of discharge.
6:30
Yes.
p.m. And he left the hospitals
Between 6 and 6:30.
Okay.
This, my lords, with even though the documentary evidence, which was, my lords, never, my lords, objected to, should have been, my lords, the even on preponderance of probability, because the Supreme Court says that he has to act fairly and consider the materials on record. The discharge certificate was duly prepared. It's just that he left, I could not give. Second, my lords, I'm coming to the Article 3 again. The charge is what, my lords, as per the imputation, your lordships have seen, is of selling of medicines. That means I took somebody's money, I sold it. In return, I got money, they got their medicines. Your lordships may see the documentary evidence at page 140 onwards.
Okay.
My lords, I want to clarify here what is the state of affairs. Sialsuk PHC, as per the defense, was that, as per the charge officer, was that, my lords, they don't have they don't have any means of giving medicines to the needy. So what the charged officer did was, she had talked to certain people with requisite license to come sell your medicines. I did not sell it. So, my lords, what was produced was the tax invoices of the uh, persons involved.
Okay,
And
what is the date?
My lords,
The
these are
documents
dated
on
11th.
that date, anything?
Yes, this is 11th May 22.
11th,
This was
okay.
prior to the initiation of the.
Okay.
This is billed to Gilead drugstore, which is in Sialsu. MS Pharmacy sold it to Gilead. My name is not at all reflected here.
140 is 11th May, the rest is.
This is 2nd May, my
previous,
lords, even prior
previous
April
ones,
is there.
okay.
Despite the existence of these on record, my lords, with bias, these have not been considered rightly. Interested witnesses of community leaders, their statements are not like that. Every departmental proceeding will end up in a finding of guilt, because all they need to do is get certain witnesses to say that, oh, he did not deny before me. Done, my lords. When in contrary, I've produced, my lords, the material evidence on record. Now, my lords, before I jump to my next last few submissions, I just want to take.
So no, but the inquiry officer,
Yes.
any mention about these documents?
Yes, yes, my lords. He had mentioned,
Did he refer to them?
my lords.
What is his finding regarding these documents?
My lords, I'll. Lords, this has not been considered. These documents. It was placed on record, and
But the inquiry officer made no mention, is
no
it?
mention.
Because these documents, you must have placed them before the
I have
inquiry
received.
officer.
Yes, yes. That's it. It seems it has not been mentioned, dealt with at all by the IO.
Anyway, you can proceed. We'll come back to this point later.
Yes, yes. My lords, before I take your lordships to 2 3 more main submissions, again, my lords, I must take your lordships through that compilation of judgments
Yes.
first. Because, my lords, I believe it will hinge on everything, my lords, these judgments. My lords, if I may, with your lordship's permission, take your lordships through certain of these extracts. My lords, we had stopped at serial number 3.
Yes.
If I may continue with serial number 4, see. The power of judicial review available to the High Court as also to this court under the Constitution takes in its stride the domestic inquiry as well, and it can interfere with the conclusions reached therein if there was no evidence to support the findings, or the findings recorded were such as could not have been reached by an ordinary prudent man, or the findings were perverse or made at the diktat of the superior authority. So, my lords, that part I rely on, that if there was no evidence to support the findings.
Okay.
7, my lords. In Nand Kishore, it was held that the disciplinary proceedings before the domestic tribunal are of quasi-judicial character, and therefore it is necessary that the tribunal should arrive at its conclusions on the basis of some evidence. That is to say, such evidence which, and that too, with some degree of definiteness, points to the guilt of the delinquent, my lords, and does not leave the matter in a suspicious state, as mere suspicion cannot take the place of proof even in domestic inquiries. If therefore there is no evidence to sustain the charges framed against the delinquent, he cannot be held to be guilty, as in that event the findings recorded by the inquiry officer would be perverse. 8, my lords. The findings recorded in a domestic inquiry can be characterized as perverse if it is shown that such findings are not supported by any evidence on record, are not based on the evidence adduced by the parties. This principle was laid down by this court in State of Andhra Pradesh versus Rama Rao, AII 1963 SC so and so, in which the question was whether the High Court under Article 226 could interfere with the findings recorded at the departmental inquiry. This decision was followed in Central Bank of India and Bharat Iron Works so and so. In Rajinder Kumar Kindra, 1984, it was laid down that where the findings of misconduct are based on no legal evidence, and the conclusion is one to which no reasonable man could come, the findings can be rejected as perverse. It was also laid down that where a quasi-judicial tribunal records findings based on no legal evidence, and the findings are its mere ipse dixit or based on conjectures and surmises, the inquirer suffers from the additional infirmity of non-application of mind and stands vitiated. Now, my lords, two judgments I'll quote from this honorable court. The next, Chitaranjan, my lords. In out here, my lords, para 8 and 17 says, further it contends that findings of departmental authority is not based on materials on record, hence perverse. Para 17, in Sawai Singh, state of Rajasthan, so and so, it has been held that where the charges are vague and the evidence is not sufficient to connect the charged officer with the alleged misconduct, departmental inquiry is vitiated for non-compliance of principles of natural justice, and the consequent order of removal from service was held to be invalid, my lords. Because, my lords, my case is also that you have found me to be not smooth, but the allegation was not issuing the discharge certificate. Your lordships.
We'll come back to the article later. Anyway, sir, continue.
Para 38, my lords. The inquiry officer failed to hold an impartial domestic inquiry, which is the essential component of principles of natural justice. The faulty reasoning of the inquiry officer attributing guilt to the petitioner, even after non-production of the complainants, made the inquiry as biased, perverse, and against the principles of natural justice. A person has been removed from the service by such departmental inquiry, which is per se illegal. All the authorities have closed their eyes to the findings of facts that is not supported by evidence at all, but on speculation and conjectures. Next, my lords, is Ankit Kumar, again another single bench judgment of this honorable court, where, my lords, what was said was disciplinary authority must establish a direct connection between the employee's actions and the alleged misconduct, failing which penalties cannot be imposed, my lords. Next is, my lords, Shirani Devi. This is Delhi High Court. Here, my lords, the honorable division bench had gone into the merits and had observed. I understand this is not binding on your lordships, but for persuasive value, my lords. Para 22. That had to be proved by leading credible evidence, which the DTC failed to do so. So, my lords, even in preponderance, whatever evidence we may bring, it has to be credible. 24 says, court found the evidence led by the DTC to be totally inadequate to prove the charge. My lords, serial number 8. I'm almost done, my lords. Serial number 8 at para 20, I believe I might have quoted para 17 also, my lords.
17. This is
21. My lords, can I take your lordships to that particular judgment? It's at serial 8.
8.
Yes, my lords. S. Muniraj. Your lordships has it. Again, my lords, another departmental inquiry, and para 17 onwards is what I would like to quote.
Yes.
Furthermore, the learned senior counsel for the petitioner submits that apart from not considering the documentary evidence, that is the general diary, the inquiry officer and the disciplinary authority also failed to take into account the deposition of PW number 10 in favor of defense. PW 10 para constable deposed that no phone call was received at about 2 a.m. On the other hand, he deposed that a phone call was received only at 5:20 a.m. Learned senior counsel for the petitioner submits that Mr. Mailis Sami was not examined as a defense witness. On the other hand, he was examined as a witness of department. If a department witness gave evidence in favor of defense, that would not be ignored by the inquiry officer and by the disciplinary authority. If they fail to take into account the deposition of prosecution witness in favor of the defense, the findings of the inquiry officer has to be characterized as perverse, and the impugned order of the first respondents based on such finding has to be set aside. In support of his submission, the learned senior counsel relied on a decision of the Honorable Supreme Court, wherein the Honorable Apex Court held that deposition of a departmental witness in favor of a defense has to be considered, and non-consideration of the same would render the findings of the EO as well as the departmental authority vitiated.
This is not the case
Yes.
here, isn't it?
Yes, my lords. My lords, here my discharge certificate and the invoices are not considered. Lastly, my lords, para 21. In support of his submission, learned senior counsel for the petitioner relied on the decision of the Honorable Apex Court in MV Bijlani, reported in so and so, and relevant portion of the said judgment is extracted here under, which reads, my lords, it is true that jurisdiction of the court in judicial review is limited. Disciplinary proceedings, however, being quasi-criminal in nature, there should be some evidence to prove the charge. Although the charges in departmental proceedings are not required to be proved like a criminal trial that is beyond all reasonable doubt, we cannot lose sight of the fact that the inquiry officer performs a quasi-judicial function who, upon analyzing the documents, must arrive at a conclusion that there had been a preponderance of probability to prove the charges on the basis of materials on record. While doing so, he cannot take into consideration any irrelevant fact. He cannot refuse to consider the relevant facts. He cannot shift the burden of proof. He cannot reject the relevant testimony of the witnesses only on the basis of surmises and conjectures. He cannot inquire into the allegations with which the delinquent officer had not been charged with. My lords, those last 5 paras are the most relevant, I would find, because it says he cannot take into consideration any irrelevant fact, cannot refuse to consider the relevant facts, and cannot shift the burden of proof. My lords, in this learned single judge's judgment of the Madras High Court, again, persuasive part is para 22. Learned senior counsel for the petitioner also submits that concerned medical officer who declared the death of the injured person was also not examined in the departmental inquiry and so, and this factor should also be taken note of this court. However, the inquiry officer recorded a finding based on the deposition of Mr. Kasparaj. He further submits that evidence of Mr. Kasparaj cannot be relied upon since he was an accused by the very same department for causing the death of injured person, and he faced prosecution under the I'm sorry, my lords, this is not the relevant.
No, this
I'm
is
so sorry.
something different.
The part where I
Maybe
wanted
you
to-
saw the doctor, medical
Yes.
officer. That's
Yes.
anyways.
I'm sorry, my lords. Where the part where I wanted to rely on additionally in this judgment was at page para, my
Para
lords,
25,
would be, my lords,
21, para 21, isn't it?
yes, my lords.
Para 21, that's what you're relying on.
Yes, my lords. My lords, this part, para 19.
And 19?
Yes. Here, my lords, it is said, therefore, if the submission of the learned senior counsel for the petitioner is confined only seeking to analyze the evidence, I could have simply rejected the same, as I cannot substitute my opinion to that of the inquiry officer, disciplinary authority, while exercising jurisdiction under Article 226 of the Constitution of India. But the learned senior counsel for the petitioner submits that the failure on the part of the inquiry officer and the disciplinary authority to take into account the documentary evidence, viz. The general diary, and also the evidence of prosecution witness in favor of defense would render the finding of guilt perverse, and that submission finds acceptance to me. So, my lords, in view of strict contrary documentary evidence in my favor, which I produced, the finding of guilt could not have been found, my lord. Could not have been found, my lords. I'll put this aside for now, my lords, and I'll come to my last few submissions. My lord, next is, your lordships has CCS, CCA rules. Rule 14. Here, my lords, and Rule 14 is the procedure for imposing major penalties. Under Rule 14,
way.
to the annexure, my lords, of this rule, unfortunately, my lords, I have this is the 42nd edition of Muthuswamy, my lords, Swami's compilation of CCS.
So we have to be on the same page. What you can do is you can Xerox what you're referring to,
Yes, my lords.
because
My lords, may I
it
pass this on?
becomes-
I could. I'll just take your lordships to the relevant part.
involving this timely payment. Was Rule 14 also?
My lords, the annexure to Rule 14. Cases in which it may merit types of cases.
Okay, go ahead. Yes, okay, you can read.
My lords, I'll just.
Not found here.
Lords, if I may take my.
Yes,
back.
please go ahead. Oh, okay. You have it Xerox later because it's not here. What have you given me here?
My lords, here in this annexure to this rule, it says the types of cases which may merit action for imposing one of the major penalties. I say, my lords,
Yes.
in the 6 type of cases which has been mentioned and specified, my case and allegations do not fit in any of these 6 specifications, my lords, to merit a major penalty.
Now, have you gone on appeal?
My lords, I had gone and the respondent said there is no appeal because Group A officers, my lords, they are appointed by and in the name of the governor. So, my lords, there is no.
So, but you can go on review?
No, my lords. The
You
review would
cannot?
not arise if there is no appeal, my lords. I had, in fact, filed. In their counter, they have actually addressed it, my lords. They themselves says there is nothing.
But the power of review will be there. Won't it be there?
No, my lords.
Just, you see,
Yes.
if it's the governor. Anyways, you continue with that point first. The government advocate can see whether he has exhausted all his, all that is available to him. Revision, review, or maybe part to, for revision also can be there, because I'm seeing it here in the rules. Anyways, power for revision, power for review, has he exhausted all his resources available to him? So documentary evidence, then yes, the punishment,
Yes. So, my lords, this is a case.
major
which did not
punishment,
merit-
does not merit major, okay.
Lordships, I have also made for assistance written submissions. Just a 4-pager. And on the last page is with regard to suspension. But before I lastly come to this, my lords, there is one legal question which is also raised in this petition insofar as Article 3 is concerned. Insofar as Article 3, my lords, is that, my lords,
Selling of medicines.
medicines.
Ah.
The Drugs and Cosmetics Act, Section 18C, my lords, is with regard to, my lords, it says about the punishment of selling medicines without license, basically. My lords, this specific section would only come into effect for every state only when there is a specific notification in the official gazette issued. As per our, my lord's submission is that this 18C has to be notified by the proper department, which is the Law and Judicial Department. What happened here was the Health Secretary had notified this particular section.
Where's the notification? Where?
My lords, I'll take your
based on what?
This is at, my lords. page number. It starts from page 247 where they've tried to answer my doubt. But the relevant notification is at page 261.
Okay, health and family.
Yes. We are saying, my lords, as per the allocation of business rules for the state of Mizoram, my lords, the Law and Judicial Department was the only department tasked with the notification of laws from time to time, my lords. Laws including notifications to the effect of any act.
Yeah, we'll have to see that.
Yes, my lords.
I don't think so. 18.
Your lordship says the allocation of business rules 2014, Government of Mizoram.
2014, there are more recent ones.
There might have been an amendment, my lords.
There are
but
lots of amendments. 2020. Get the latest one.
yes.
That 2014 is an old one.
As per my instructions, my lords, this may be the latest.
Anyway, you give me a copy of that.
Yes, yes.
Location of this, it's old. That is old. There are more recent ones.
My lords, I'll check up on that. Lastly,
Anyway, that's
the legal-
a side issue concerning this, but we'll have a look at that.
So, my lords, I come lastly on the suspension order. Because, my lords, what happened here was the suspension order, because of the inquiry proceedings, was issued on 2nd of June 2022, which is at page 38. Whereas a disciplinary case against Dr. Linda is contemplated. Now, therefore, the Governor of Mizoram is pleased in exercise of the powers conferred by
Page 38, yes.
38. Now, therefore, the Governor of Mizoram is pleased in exercise of the powers conferred under Sub-Rule 1 of Rule 10 of CCS rules. Hereby places the said Dr. Linda under suspension with immediate effect. It is further ordered that during the period that this order shall remain in force, the headquarters of Dr. Linda Lalbiaknungi Public Health Center should be Aizol, and the said Dr. Linda shall not leave the headquarters without obtaining the previous permission of the undersigned. My lords, after this suspension order, at page 168 is the order by which this suspension order was revoked. Page 168. Whereas an order placing Dr. Linda under suspension was made on 2nd of June 22. Now, therefore, the Governor of Mizoram, in exercise of powers so and so, hereby revokes the said order of suspension with immediate effect. Thereafter, my lords, surprisingly, is the order at page 169. Consequent upon revocation of suspension order dated so and so, Dr. Linda was reinstated into service and was posted to Directorate of Health Services dated so and so. Treatment of the period of suspension and payment of pay and allowances thereof shall be decided on finalization of the case. This is made in 22nd March 2023, my lords. So, my lords, they said on finalization of the case
Case, what case?
of
Okay,
the
was-
disciplinary proceedings.
Okay.
Yes, my lords. I was placed under suspension when it was initiated. Then they said that they revoked it. Then they said they will decide how to regulate that period of 3 months on finalization of the case.
So
They
when was it finalized?
Yes. My lords, that finalization is at page 275.
Hmm.
275. In continuation of order dated 22nd 3rd March 2023 and consequent upon finalization of the disciplinary proceedings against Dr. Linda, the period of suspension may be treated as on duty for all purposes except on pay and allowance. The pay and allowance for the period of suspension of Dr. Linda shall be restricted to subsistence allowance already drawn. This is how they finally regulated my period of suspension. Now, my lords,
So you want your full pay?
yes, my lords, this suspension regulation orders have been passed in total violation of the rules. Rule 10.6 and Rule 10.1. Now, my lords, what Rule 10.1 says is of the CCA rules. Rule 10.1 says, the appointing authority to which...
Wait, just a second.
I'm sorry.
Rule 10. Yes,
Yes, my lords.
yes, please
The
read.
appointing authority or any authority to which it is subordinate, or the disciplinary authority or any other authority empowered in that behalf by the President by general or special order may place a government servant under suspension where a disciplinary proceedings against him is contemplated or is pending, or where in the opinion of the authority officer has engaged himself in activities prejudicial against him in respect of any criminal offence. I fall under 1A, my lords. Now, if your lordship turns to the next page at sub rule 6, an order of suspension
Yes.
made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before expiry of 90 days from the effective date of suspension. So, my lords, every 90 days,
Every time
has
there's,
to
it extended
Yes,
also.
ma'am.
So,
in my case,
huh.
they had revoked it, that too after a period of 90 days, my lords. So they had lost their power to regulate it altogether. And I have judgment straight on that point. On the recommendation of review constituted for the purpose and pass orders either extending or revoking the suspension. So they've
So it's
revoked it.
usually extended if no
Yes.
steps have been taken within the period of 90 days. Then they extend the period.
Yes.
So when were you suspended?
I was suspended on my lords.
22/6,
No, no.
2022.
2nd of June 22.
Okay, this is second. Huh?
Yes.
Okay. Huh.
Revoked 26th September 22. Beyond the period of 90 days. Revocation is also bad. Thereafter, my lords, it was decided, another letter was issued, order I would say, 22nd of March 23, whereby they said, on finalization of the case, we will regulate that period.
Anyway, we'll have to see. Yes, okay, a very point.
Yes, my lords.
So give me authorities on this.
The Supreme Court judgment in Union of India versus Deepak Mali, para 10 and 11, my lords. Having carefully considered the submission made on behalf of the parties and having also considered the relevant dates relating to suspension of respondent, when the petitioner's case came up for review on 20th October 2004, we are inclined to agree with the views expressed by the Central Administrative Tribunal has confirmed by the High Court that having regard to the amended provisions of Sub-Rule 6 and 7 of Rule 10, the review for modification or revocation of the order of suspension was required to be done before expiry of 90 days from the date of order of suspension. And as categorically provided under Sub-Rule 7, the order of suspension made or deemed would not be valid after a period of 90 days unless it was extended after review for a further period of 90 days. The case sought to be made out on behalf of the petitioner Union of India as the cause to the delay in reviewing the respondent case is not very convincing. Section 19 of the Administrative Tribunals Act speaks of abatement of proceedings once an original application under said act was admitted. In this case, what is important is by operation of Sub-Rule 6 of Rule 10 of 1965 rules, the order of suspension would not survive after the period of 90 days unless it was extended after review. Since admittedly the review was not being conducted within 90 days from the date of suspension, it became invalid after 90 days. Since neither was there any review nor extension within the set period of 90 days, subsequent review and extension in our view could not revive the order, which had already become invalid after the expiry of 90 days from date of suspension.
Revocation order was made soon after, isn't it?
Yes.
And then this order
Yes.
dated 22/3. Let's see this, page 169. After revoking the order, there's another order, 169. What is the nature? Treatment of.
Of how they'll regulate minors on finalization of case. That too made months
The
after
treatment of period of suspension and payment.
pay and allowance thereof shall be decided on finalization of the case.
This we'll have to see, this order, 169. I think the government advocate will have to explain this, because after it has been revoked, then later, when was the impugned order again? On 22/5/2024, is it?
22/5/2024. Yes, ma'am. Correct.
So in between that is in between this period,
Yes.
22/3/2023 and 25/5/2024, she was receiving the substantial, what
No, no.
allowance? Full,
My lord, she was getting her full pay.
Full
It's
pay.
only for the period of the suspension.
okay,
It is from 2nd June.
okay, till the date of revocation. Okay, it's okay.
Yes, ma'am. My lords, just for, I understand I have taken your lordships most of the hearing, my lords. I just want to reiterate the points. My lords, my first submission, I've given this small written submission
Oh, good,
to assist your lordships. My lords, the law is clear that your lordship's interference is warranted only in specific circumstances. We are also saying we fit in those circumstances. Therefore, our first point is that the CEO was found guilty for an alleged misconduct she was not charged with. No evidence was tendered to prove the charge with which she was imputed. If we see, my lords, Article 1, she was charged with statements of witnesses, interested witnesses, who said, my lords, that she had admitted her guilt before us. That in our humble opinion, my lords, in view of the discharge certificate which was already on record, that material had to be, my lords, weighed against the statements, even if they were admissible. Because, my lords, every departmental proceedings would end up in finding of guilt, all the department has to do is get anybody from any corner, say this, that he is admitted his guilt.
Okay.
And my lords, insofar as Article 1, the charge was, and I respond to your lordship's query, that the charge was of not discharging the deceased. It may have been in connection with anything, including that of, my lords, the missing of the monies, and that an FIR was, my lords, so and so, police.
So you're saying that this sentence should be broken into half. It should be only this,
No, no,
and
my lords.
in connection should not be read.
No, my lords.
Then,
The
without proper discharge certificate. Now your submission is that there is a proper discharge certificate
Yes.
because the document.
yes, and the
So only till there.
yes.
Okay.
The finding of guilt was that I have not acted smooth enough, as your lordship saw. Therefore, my lords,
In issuing the discharge certificate.
yes.
Okay.
Therefore, my lords, Article 1, it is totally based on, my lords,
So there's no violation of Rule 3(1)(3).
my lords, those violations would have to, yes, based on the specific substantial allegation made.
Then the next one, the third one is medical
Yes, selling of
drugs,
Drugs.
where you have produced the invoice.
Invoices.
Showing that it is sold by this. Okay, fine.
not at all considered.
Those are the points, isn't it? Yes. Now, I think it's 5 minutes to lunch break. So I think it's better if we continue at 2. What about your points? Lengthy or
Your Lordship, it is not lengthy, but I'll be very, very
more? Okay.
quick in my
It's going to be
submissions.
quite elaborate also, that means. Then we'll continue it. Yes.